this. The reason that we record these is so if you can't make it, or just are, really enthralled by the sound of my voice and feel like you learn the concepts better as a result of having me say them out loud, I'm really excited to tell you that you can find a lot of these on YouTube. And you go to our Keller Williams Greater Metropolitan Training, just search that on YouTube. And you can find the last couple months worth of sessions where we've covered just about every one of these, and have a lot of folks who consume that if they're working in the evenings or have kids that they got to take care of or something like that. So make sure you take advantage of that. All right, first one I saw tonight was law. So Will, let me know, you looking specifically for the license law and rules of the Ohio Real Estate Commission? Is that the one we're going for? I guess I don't see law anywhere else. I just feel like there should be another one. All right, and then we'll run through math as well as agency law and contracts. All right, so we're going to dive in here. I'm going to read the question, read the A, B, C, D as the answers. Just need you to hop in the chat and let me know whether you think it's A, B, C, or D. Whatever the group thinks, we'll go with. If we all get it right, we'll move on. If we all get it wrong, we're going to have a real serious conversation. All right, here we go. A broker offers a seller a free trip to Hawaii in return for a property listing. What is true? A, the broker must disclose this in the real estate sales contract. B, the broker must disclose this in the listing contract. C, the buyer and seller must agree to this inducement. Or D, the broker must disclose this to any potential buyer. All right, we got B's and D's and A's. All right, I think, and now a C. Thank you, Stacy, bringing it all around home. So the answer is going to be B. So why is that? So the broker offers a seller a free trip in return for a property listing. So this relationship does not involve the buyer at all, right? What inducement was required for the seller to list is exclusive between the seller and the broker. So it only needs to show up and be defined in the listing contract. If there's an inducement to purchase, right? Hey, if you buy the house, we'll put in all new carpet. That needs to be disclosed in the sales contract, right? Because that impacts the buyer and the seller. If it's something that is just an inducement to secure a listing, it only needs to be disclosed in the listing contract. The buyer doesn't need to know how that listing agent or listing broker got that listing. Does that make sense? Give me a head nod if it does. All right, lovely. When would a license be considered inactive? A, when the broker dies. B, when the salesperson directs the broker to return the license to the division. C, when the salesperson fails to turn in proof of CE. Or D, when the salesperson does not have a transaction in a mandated period of time. All right. So seeing B's and C's in here, and it's going to be B. So inactive status is voluntary. If you fail to produce CE, your license is going to be suspended, right? And there's not enough information to really say what happens here when a broker dies. We need to know what else is going on inside of the office, and that would tell us if it's going to go to probate court or if the superintendent's going to appoint a new one. And then there is no minimum number of transactions required to maintain an active license. So Inactive status is a voluntary one where you just tell your broker, hey, I want this to go inactive. Which of the following is a violation of license law? A, having acted as a broker without authority, impeded the ability of a principal broker to perform any of the duties, or impeded the ability of a management level licensee to perform licensee's duties. B, hire other salespeople from a different brokerage. C, offer trainings to pre-licensed agents. Boy, I hope that's not a thing. Or D, offer a free CMA to a landowner. Yeah, it's any of the things in A, right? If you get in the way, pretend to be a broker, or stop a broker or anybody as a management level licensee from doing their job, you would be violating license law. All right, which of the following grants the broker the exclusive right to represent the purchaser in the purchase or lease of property? Is it A, a consumer guide to agency relationships, B, an agency disclosure, C, a buyer listing agreement, or D, an exclusive purchaser agency agreement? All right, good job with the D's. The buyer listing agreement is a oxymoron. Buyers don't have listings. The buyers are purchasers, and an exclusive purchaser agency agreement. You're going to hear a lot about having people sign those. And then agency disclosure and consumer guide to agency are things that are required as you move into a relationship with any client, but does not provide an exclusive right. It only defines that relationship. Which of the following is not a management level licensee? Is it A, a salaried licensed office manager, B, an associate broker, C, a new salesperson, or D, a team leader? That's right. The only one of these that is not a management level licensee is going to be a new salesperson. Everyone else, whether it's the owner of a team, then associate broker, or somebody who is a salaried licensed office manager, those are all going to be management level licensees. If they were not licensed, it was just a salaried office manager, right, to run the administrative staff, they would not be a management level licensee because they're not a licensee. All right, a broker loses her license and there is no licensed broker to take over the broker's business. In this case, A, the sales agents may take over the listings. B, the sales agents may take over the listings that are in contract. C, the probate court must approve the appointment of an ancillary trustee. Or D, an ancillary trustee may be appointed by the superintendent to conclude the broker's business. All right, looks like the D's have it. Here's the important thing to remember. If nobody dies, probate court will not be involved. If somebody does die, probate court could be involved. In the event that there's another licensed broker, they'll take over. Right? We have about 7 or 8 licensed brokers in our office. So God forbid anything were to happen to our principal broker, you would not feel anything different with your business, or wouldn't impact you at all. In the event that there is a broker dies and there's no licensed broker, probate court is going to get involved. So anytime you see probate court, it's because someone died. Anytime someone dies, probate court could be involved. All right, if the superintendent pays any amount from the recovery fund in the settlement of a claim toward the satisfaction of a judgment against a licensed broker or salesperson, then A, the license of the broker or salesperson is automatically revoked. B, the salesperson or broker must pay a fine of $2,500. C, the license of the broker or salesperson is automatically suspended. Or D, there is no action against the broker or salesperson as the fund is set up to protect the public. we got C's and D's and B's. So it's going to be automatically suspended until the broker or salesperson repays whatever was paid out of the recovery fund, right? So if they pay out $1,500 out of the recovery fund because of something that you did, your license is going to be automatically suspended until you pay that $1,500 back. So suspension is the default here. All right, question number 8. A sales agent in his advertisement states in his advertisements that he will provide a free room addition to anyone who buys one of his listings. What's true here? A, this is unethical, as the sales agent is not allowed to offer an improvement in real estate as an inducement. B, this is legal as long as the inducement is disclosed to the buyer and seller. C, this is unethical as a sales agent may not offer anything as an inducement. Or D, this is legal as long as it's noted in the sales contract. Man, we've got BA, DB, DC, B. All right, seeing the majority B's here. It's going to be D. Now, I know this feels like, well, aren't they kind of saying the same thing? You want it to be disclosed in the sales contract, period. Any inducement has to be disclosed in the sales contract, which then is a form of disclosure to the buyer and seller. So I think it's a poorly worded answer in question B, but know that the top of the funnel here, the thing that guarantees disclosure to buyer and seller is that it's in the sales contract and therefore a part of the obligations to everybody involved. The unethical or illegal thing is to offer it as a offer improvements to real estate or real estate itself as a prize in a lottery, right? Buy a ticket for $500, maybe you win a free room addition, maybe you win a free house or something, right? So you can't do that. You can't involve games of chance. But in the event that somebody's like, hey, I'll buy this house if you put a new roof on it, I mean, that's the equivalent of an inducement. That needs to be disclosed in the sales contract so that there's accountability inside of the contract and also disclosure. A person making an application to the recovery fund for payment must file an application to recover within what period of time? A, 60 days after the termination of court proceedings. B, 1 year after the termination of all court proceedings. C, 90 days after the termination of all court proceedings. Or D, there's no statute of limitations on claims here. So they got to file no later than, right? No later than, you guys nailed it, 1 year after the termination of all court proceedings. Question number 10. What lien automatically attaches to a commercial property to secure a broker's commission? A, attachment lien, B, broker lien, C, mechanics lien, or D, judgment lien? All right, B's gonna be the answer. The trick here is you just have to know that here's the way I remembered it. In the commercial real estate sector, they call agents brokers. In the residential sector, they call brokers brokers. So commercial agents like to think pretty highly of themselves, so they call themselves brokers. If you keep that in mind, you'll know that any lien related to commercial property is going to be a broker's lien, right? If there are unpaid services, like a contractor comes in and puts a new roof on the house and then you don't pay him for the roof, that's going to be a mechanics lien. Any sort of improvement is going to be related to a mechanics lien. Right? Those are the two that you want to stay dialed in on. Broker liens are for commercial properties. All right, upon the death of a licensed broker, what might occur? A, the Ohio Real Estate Commission appoints an ancillary trustee. B, the sales agent takes over the broker's listings. B or C, a broker within the business entity of the deceased broker takes over the listings. Or D, the superintendent appoints an ancillary trustee. What might occur? What might occur? C's and D's are neck and neck here, guys. Nope. I thought Cheryl put us over. Will brought us back. The answer is going to be C. And here's why. This might occur if there's another broker inside the entity, but those would just transfer. It doesn't have to involve appointment by the superintendent. If there's no one to take it over and the broker dies, there is an appointment by the superintendent of an ancillary trustee that has to be approved by in probate court, right? So the key thing that you're looking for there is, for the superintendent to be involved, probate court has to be involved. Remember, I said if somebody dies, if a broker dies, it might involve probate. If there's another licensed broker in the shop, it doesn't have to. But if there isn't, then it will involve probate and the superintendent and the appointment of an ancillary trustee. Is everyone tracking on that? If somebody dies, it could involve probate. If nobody dies, it will not involve probate, right? So death or no death is, if you see probate but no death, that's not the right answer. If you see probate and there is death, it might be the right answer, depending on the circumstances. All right, the principal broker has the following duties, except A, comply with office requirements, B, prepare listing agreements, C, comply with fair housing, or D, oversee and direct operations. Yeah, the only thing that they're not going to do here, and really for the purposes of understanding, what does a broker do? They oversee and direct operations. They have to comply with the office requirements because they're the ones setting the office requirements. And then they have to comply with fair housing requirements, which we all do. They don't have to prepare listing agreements. That's something that an administrative professional can do. All right. Under the Ohio Real Estate Recovery Fund, the commission shall impose a special fee not to exceed $10 annually on each licensee filing a notice of renewal if the recovery fund is less than A, 500,000, B, 2 million, C, they can do this anytime, or D, 3 million. So what does it have to be below to be $10? All right, seeing enough A's. It's A. So if it's under 500,000, it's $10, which is the most that it can be, right? If it's between, what is it? If it's between $1 million and 2 million, it can be $5, up to $5. And if it's over 2 million, then there's no imposition. So 0 to 500,000 is up to $10. Sorry, I want to make sure I get this right because I threw myself off there. Commission shall impose a special assessment not to exceed $5 if the fund is greater than $1 million, but less than 2 million. Yeah, so 0 to 5 or less than $500,000, $10 per licensee. $1 million to 2 million, $5, no greater than $5, and then they can't charge anything if it's at or above 2 million. After recording an affidavit of lien with the recorder's office, the broker shall provide a copy of the lien affidavit where the contract for sale or other conveyance of the lien property has been entered into to whom? A, the superintendent, B, the prospect of the transferee, C, the owner of the lien property and the prospective transferee, or D, the owner of the lien property. So when you record an affidavit of a lien at the recorder's office, who needs to get a copy of that? Looks like the C's are in the chat, and that's correct. The contract for sale, or however, whatever other tool that's been entered into the affidavit after being recorded has to be served certified mail to the property owner, and if known, the person that it's transferring to. From where does the real estate licensee get the 19 articles of the Canons of Ethics? Is that from the Ohio Association of Realtors, B, the Ohio Real Estate Commission, C, the National Association of Realtors, or D, the Division of Real Estate? Who is responsible for the 19 articles of the Canons of Ethics? All right, so here's an easy way to remember this one, I don't know if it's easy, but it's the way I remember it. The National Association of Realtors and the Ohio Association of Realtors are professional organizations, and both of those have a code of ethics. When it comes, they cannot negatively impact your license status, right? Those are just associations. Like I belong to my college fraternity, or stitching club, the Knitting Kittens that I belong to, right? Like, okay, so those are just clubs, they're organizations, they're professional affiliations. I don't actually knit, but the Ohio Real Estate Commission can actually negatively impact your license status. And so I always like to think of it as the fact that canons can hurt you. And so the Canon of Ethics, Canons of Ethics belong to the Ohio Real Estate Commission. The Code of Ethics belongs to everybody else. The Division of Real Estate, they do things with your license status, but the commission would actually be imposing things based on the canon. All right, how many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? Is it A, 25, B, 30, C, 26, or D, 20? It is 30 hours, and you can get 30 hours of continuing education over the course of 3 years by just attending the continuing education that we will offer in our office. So you don't need to go out there and find it or buy any packages or do anything like that. We offer continuing education on a consistent basis. All right, a homeowner is selling his house without the aid of a broker. The homeowner advertises that he will give anyone who buys his home 2 free airline tickets to anywhere in the continental United States. No trips to Hawaii or Alaska. What is true? A, this inducement is in violation of the Ohio Revised Code licensing law. B, a seller is not authorized to give an inducement in this manner to an unrepresented buyer. C, this is perfectly legitimate and does not need to be disclosed in the sales contract. Or this inducement, like all inducements, need to be disclosed in the sales contract. D is correct. All inducements. Wait, what? Oh, I misread this somehow. Oh, okay. See, I got a little cocky here, guys. Can happen to the best of us. Ohio licensing laws state that a broker or sales agent must disclose in any contract any additional considerations for inducements. There are no sales agents or brokers involved here. Who put C in the chat box? You clever devil. Nicole. No disclosure is necessary on behalf of the homeowner, right? So you could put this in your portfolio of things to tell potential buyers that want to be unrepresented, that or even sellers that want to use, I guess buyers. But if there's no realtor involved, the obligation for disclosure because of licensing law is void because no one's licensed. Sorry, that was my oversight there. Shame on me. What is the maximum number of DBAs or doing business as names a broker is allowed to operate under? A, only 1, B, no more than 3, C, no more than 5, or D, no more than 2. The answer is going to be C, no more than 5. You can have 5 DBAs, which DBAs are just different names for your business or your LLC. Ours is Keller Williams Greater Metropolitan. That's a DBA. Before we were Greater Metropolitan, we were Greater Cleveland. That's another DBA. The name of the LLC that holds the franchise for Keller Williams is called the Merwood Real Estate Group. So the DBAs go on top of Merwood as how we represent who we're doing business as. When must a broker record a written release or satisfaction of a broker lien in the county recorder's office in which the lien was recorded? Is it A, the owner must file the release of the lien after the claim has been satisfied, B, within 15 days of that claim being satisfied, C, within 10 days, or D, within 90 days? Neck and neck between C and B. Let's go with C, and C is correct. Must be recorded within 10 days after the claim is satisfied. So somebody puts a broker lien on something, you go pay it, and then that satisfaction or written release has to be filed within 10 days. Homosexuality is protected under what federally protected class? A, it is not protected under any federally protected class. B, sex. C, national origin. Or D, familial status. A is correct. It is. There are local ordinances in some cities, but it is not a federally protected class. All right, guys, that was a busy one. A lot going on there. A lot of good stuff. Now that's from the state portion. The state portion, there's only 3 sections, and 2 of them are, probably 85% of the questions. So between that and I believe, well, I'll put it up at the end, but I believe it's the brokerage relationships, state government. State governance is going to be the other really big one. But let's knock out agency law just to stay on the state subject. Or maybe this is the other big one. All right. Well, we might be here for the rest of the night. What is not the fiduciary duty of an Ohio real estate licensee? A, care, B, loan arranging, C, obedience, or D, accountability? That's right. You guys are not going to be arranging any loans. You're going to partner with mortgage companies or loan officers to help you do that. When can a broker reveal confidential information about a client? A, under subpoena. B, when the listing expires. C, never. Or D, under no circumstances. Yes, when you are subpoenaed, you will have to relinquish confidential information, but otherwise, never. You would never be able to do that. A real estate licensee owes the fiduciary duty of confidentiality to the seller until A, a commission's paid, B, forever, C, 1 year after the contract expires, or D, when the contract expires. So if you're never subpoenaed, you owe confidentiality forever. All right, while you're on floor time, a buyer asks you to run the MLS and let them know what's available. You tell him you need to ask some questions in order to know what price range he's in, and he agrees. You pre-qualify him yourself and pull up a number of listings, schedule showings, and sell him a home that weekend. The law requires you to A, have a lender do the pre-qualification, B, give the client a consumer guide to agency relationships, which outlines the brokerage policy before you start working with the client, C, do as he asks. After all, you must follow the legal instructions of your clients. Or D, give him an agency disclosure before you show him the first house. All right, the B's fill the chat box, and that is going to be correct. The key terminology is the first substantive conversation. So the consumer guide and summary on company policy must be given to the client before you start working with them. The buyer could go to a lender for pre-approval while you're working with them. If you ask financial questions before you show homes, then you must give the disclosure prior to asking those questions. So when you have your first substantive conversation. Which fiduciary duty survives the termination of a real estate listing? A, obedience, B, confidentiality, C, loyalty, or D, financing? They are really hammering confidentiality here because that's the one that sticks around forever. The other duties are terminated when the when the deal closes or the listing is terminated. A real estate agent is selling Ohio property that is owned by a resident of Indiana. The buyer is a resident of Florida. The real estate agent must be licensed in A, Ohio, B, Indiana and Florida, C, Indiana, or D, Florida. Yeah, not a trick question, guys. You sell property in Ohio, you got to be licensed in Ohio. You want to sell property in Indiana, you got to be licensed in Indiana. Where the buyers and sellers are, you will quickly find out. In a popular town like Cleveland, they come from all over the world. And that doesn't matter. You got to be licensed here to sell this land. A sales agent is found guilty of a violation of the Ohio Revised Code involving non-disclosure of agency relationship. What is the liability of the sales agent? A, a fine not to exceed $2,500 per violation. B, immediate revocation of the salesperson's license. C, jail term not to exceed 30 days. Or D, criminal penalty of a 4th degree misdemeanor. Everyone feels pretty strongly that it's A, and it is. They can fine an agent up to $2,500, suspend the license. Revocation would not be immediate. No criminal charges are filed. No jail time is assessed. A buyer signs an agreement to purchase a home. The seller has not provided a property disclosure form. When the buyer requests the property disclosure form, the seller refuses to provide it. What rights are available to the buyer? A, the buyer may rescind the contract. B, the buyer may sue for liability. C, the buyer may request only that the seller deliver a property disclosure statement within 3 days after the agreement has been signed. Or D, the buyer may sue for 3 times the damages for defects not shown. All right, looks like we feel pretty strongly that it's going to be A, and we're going to be right. You can rescind that offer. You can't sue for liability. The only right the buyer has here is to rescind the contract. They can request it from the seller at any time. Law doesn't give the buyer the right to sue for any damages either, because if you go through with the deal, you're waiving that right. You're waiving your right to the property disclosure if you go through with it. All right, sellers have informed a listing broker that if necessary to sell the property, they will accept $10,000 less than their asking price. Another agent in the firm finds this out and informs a buyer about the $10,000 reduction. The second sales agent has signed the buyer to a buyer representation agreement with the same firm. What is the duty of the listing agent? A, the broker can sue the buyer. B, the seller may not sell the property to the buyer. C, the seller can sue the buyer for specific performance. Or D, the listing agent must offer to withdraw the listing. So what happens here? You leak some information, or some information got out. Yep, you got to come clean on it and offer the confidentiality has been breached. It's appropriate to go ahead and offer to withdraw the listing. A broker is representing a buyer. A buyer expresses an interest in a property that is advertised in the paper for sale by owner. The broker calls the seller and asks to show the property to the buyer. When must the consumer guide to agency relationships be given to the seller? A, prior to negotiating the sales contract. B, prior to sending the buyer for financing. C, during the telephone conversation, the broker must disclose to the seller the fact that he represents the buyer. Or D, prior to showing the seller's property to the buyer. So when must the consumer guide to agency be given to the seller? So what do we have here? Where do you guys start now? C's and D's. It looks like the C's have it, and that's going to be correct. First substantive contact is by telephone, and that's when the written agency relationship must be disclosed. The actual disclosure statement must be given prior to the first physical contact, but the seller must be told of the relationship at the first substantive contact. A buyer asks a sales agent to prepare a land installment contract. The sales agent goes to the local legal publishing mart and purchases a pre-printed sales contract form. The sales agent proceeds to fill out the pre-printed form. What is true? A, this is not unauthorized practice of law, as the sales agent has used a pre-printed form. B, this is unauthorized practice of law. C, there is no violation to the Ohio Revised Code. Or D, this is a violation of the Ohio Marketable Title Act. Looks like the group feels pretty strongly that it is B. And that is correct. A sales agent or broker may complete only a pre-printed sales contract form. Under no circumstance is a sales agent or broker or may a sales agent or broker complete a pre-printed land installment contract, option, a lease, etc., unless he or she is party to the transaction. So in terms of sales contracts, you guys are going to use pre-printed forms all the time. When you get into land contracts and leases, those are big no-nos. Those should be prepared by either the landlord, an authorized property management company in terms of a lease, or a lawyer. I do commercial real estate. I run into a couple of these from every year. Just hire a lawyer. It's a few $100, get it done. A sales agent represents a seller in a listing. What are the agent's duties to the customer? A, care. B, loyalty. C, accountability. Or D, honesty and fairness. It's D. We owe honesty and fairness to everybody involved in the process, including our clients and customers. Our clients are due accountability, care, obedience, disclosure, and loyalty. Broker Bill Brewer engages in an exclusive agency listing with his clients and the sellers enter into an agency relationship in which the seller is going to market her own property. What document must be included in the listing file? A, a land contract, B, a lease, C, an option, or D, a waiver of duties statement? D, a waiver of duties statement is correct. You have to have that in there saying that you were the seller is going to be responsible for marketing his or her own property. Question number 14, a listing broker is holding an open house and a buyer walks in and views the property. This will happen. The buyer does not like the property, but asks to be shown a house down the street. 2 days later, before showing the other property, the broker calls the buyer and asks specific questions about specific financial information to determine the price range the buyer can afford. Then the broker sends the buyer to a local bank for pre-qualification. After pre-qualification, the broker shows the property as originally requested. When must the consumer guide agency relationships be given to the buyer? Whew, long question. A, when the buyer went for pre-qualification. B, prior to requesting specific financial information. C, prior to showing the home. Or D, at the open house. Look at you guys doubling down on B. And that's correct. When you get into specific financial information, that's going to be a trigger. Showing any property other than the open house, that's going to be a trigger. Prior to initiating any sort of pre-qualification, which is usually going to involve financial information, or prior to discussing making an offer, prior to submitting an offer. All of those should be triggers for a consumer guide to agency relationships document to be signed. Question number 15, a licensed sales agent is contemplating selling her own property. What must the sales agent do to comply with Ohio law? A, disclose the type of agency being offered. B, disclose at the listing that she is a sales agent. C, disclose in any advertisement that the property is being sold for sale by an owner/agent. Or D, disclose the type of lending being offered. C, disclose in all advertisements that this is being sold by an owner agent. Disclose, 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 disclose. Always disclose that you are an agent. Agent Samuel Smith decides to sell his house. He lists with his broker and the marketing begins. Agent Smith holds an open house and a buyer comes into the open house and wants to make an offer. Which is the only option not available to Agent Smith? A, treat the buyer like a customer. B, act as a dual agent. C, act as a split agent. Or D, refer the buyer to another agent. What is the only option not available to our friend, Agent Samuel Smith? All right, the B's have it, and the B's are correct. Under this law, the practice, you cannot practice dual agency on yourself. Dual agency is something that you can do as long as it is disclosed and all parties agree to it. However, you cannot do it if you are one of those parties. You can't say, I'm going to represent myself and I'm going to represent you in your best interests as well. It just doesn't seem like a recipe for success. A seller dies during a 90-day listing agreement. What is true? A, the broker can sue the seller's estate for specific performance. B, the agency agreement is still in full force and effect. C, the agent can sue the seller's estate for specific performance. Or D, the agency agreement is terminated by operation of law. Yep, you guys are all over that. somebody dies, the contract is terminated. Now, this is also the case if the buyer dies, seller dies, anybody, if the agent dies, it doesn't really matter. I'm sorry to tell you, in a real estate deal, if you're party to a contract and you die, it'll stay with the brokerage and somebody else will take it over. But if the buyer or seller die, it terminates the contract. At what point in time must an agent give a buyer a consumer guide to agency? And now, guys, there's a reason these questions keep coming up. This is one of the few things that, I shouldn't say the few things. There's a lot of things that are important about what you're learning here for your real estate career, but giving the consumer guide to agency, making sure people understand that they are being represented and that you represent them, and what that exactly means and entails is a very important part of a little thing called CYA. And that is cover your rear end. And so when you're doing that, you're putting yourself in a position that should anything go wrong, and I've seen not even things go wrong, but if you're accused of any wrongdoing, the very first thing that our legal counsel is going to ask you for is a copy of the consumer guide to agency. And if you're under contract, the agency disclosure documents, right? If everybody knows who everybody is in the equation, that's 90% of the of things can be sorted out. If it's like, well, you signed this document that said that they were representing you, or you signed this document that said you were representing yourself. It's very important. So when must it be given to the buyer? A, at the loan application table. B, prior to the second showing. C, prior to showing in an open property at an open house. Or D, at closing. I can't tell. It looks like, when did these start? Okay, so maybe B's and an A and a C. B is going to be right. It's a poorly worded answer, but if you're holding an open house and somebody walks in, you do not need to give them an agency disclosure document, or the consumer guide to agency relationships, I should say. But if they call you up and they say, hey, I was at your open house on Saturday, I'd like to come back, you have to say, okay, are you currently working with an agent? No. All right, I'm going to have a consumer guide to agency ready for you, just because this is considered a substantive contact and you will need to do that. A listing agent offers a seller an inducement to lower the sales price and accept an offer of a purchase contract. What is true? A, this arrangement is legal as long as the inducement is not more than the commission. B, the agent must disclose this information to all parties. C, the agent must disclose this information in any advertisement. Or D, this information may be kept confidential between the listing agent and the seller. So the listing agent offers a seller an inducement to lower the sales price. What is going on here? I'm seeing B, B, D, D. Somebody break the tie. Will broke the tie. And that is correct. As a buyer in a transaction like this, you are not party or privy to anything between the listing agent and the selling agent if it does not impact you, right? A reduction in price, me saying, hey, listen, you think this house is worth 200,000. I know it's worth 180. I'm at a 7% commission here. I'll go to a 5% commission if you drop it to 180, right? And then that's an inducement. It's an adjustment to the contract of our relationship. And then a buyer comes along. All they need to know is the house is 180. If they want it, they got to buy it. A consumer guide to agency relationships form must be provided for all of the following except A, an office building, B, a condominium, C, two-family residence, or D, a single family residence. Which one of these does not require? Yes, that is right. It is an office building. I will tell you it is not required by the state. However, if you are party to a commercial transaction with our office, A, you have to work with a commercial specialist in our midst. And two, you are still required to have the agency disclosure and the Consumer Guide to Agency Relationships completed. We do that to protect you first and foremost, even though the law would say it's a redundancy or unnecessary. All right, guys, that's going to bring us nearly to the top of the hour. Don't go anywhere just yet. I'm going to give you the thing that I give you every week, which is the exam breakdown. In terms of what questions, how many questions come from what sections. So this first piece right there, what you're looking at is the national exam. So you got to get 56 out of 80 questions right to pass the national exam. And then from a state exam standpoint, I need you to get 28 of 40 right from those three sections. As you can see, it looks like I'm missing a section on the licensing requirements for state, but state's pretty well distributed, right? So you just got to know it all, and I don't mean know it all, but there's no real trick to mastering specific sections. However, in the national portion, you can see contracts, practice of real estate, and general principles of agency are 35 of the 80 questions, right? So if I need to get 56 right and I can ace those three, I'm more than halfway to where I need to be to get my real estate license. And then obviously financing, transfer title, and property ownership are your next wave. But as you invest your time, energy, and resources into studying, study the places that have the most questions. If you are the master of all things leasing and property management, it will likely not make a difference on your exam. There will be 2 questions. And one of those questions is probably going to look and feel a lot more like contracts than it does like property management, or is going to be related to some sort of agency disclosure or consumer guide. So when you study the big ones first. That's why we try and spend our time there here. And yet, don't give up easy points around land use or state governance and anything like that, because those 4 questions can make the difference. As I said, we will be back on the same link, but Monday night next week, we'll resume the reminders that'll be taking place weekly to let you know that we are holding those. You probably are, for you regulars, you're probably missing a couple of normal faces. That's because we got people passing exams. So if you are sitting on your hands or you're nervous about scheduling or anything like that, get in the game. And you know what? If you, as we've had several people do, if you pass national and not state, guess what? You only got to take state. You pass state, not national, guess what? You only got to take national. You get right back in the saddle, and nobody is ever going to ask you when they call or come to your open house, how many tries did it take you to pass your real estate exam, right? I think of it a lot like being the person who finishes dead last in med school. They still call that guy or gal a doctor, don't they? If you need a 70% to pass, we're here to help you. If you haven't scheduled your exam yet, do so. If you haven't got the materials yet to schedule your exam and it's been a couple, 2-3 weeks, let me know. If you have any questions at all or need anything, I'm here for you. Let me know. Otherwise, have an awesome Tuesday, and we will see you next Monday. Take care, guys.